So thank you so much, Danny, wherever he is, and Daniel and Harry, and everyone else who had a chance to look at this draft. The paper's titled Antitrust Abandonment. You must give things a catchy title if you want to get them published. It's about federal industry regulators or departments that are not the FTC or DOJ, but that hold antitrust-like enforcement powers. And so the central claim is that these industry regulators do not enforce these antitrust-like provisions in their empowering statutes. And it uses this history of inaction to inform current digital debates. So when I say antitrust-like provisions, these clauses are strewn across industry-specific statutes, so outside of what we might think of as the general antitrust laws, but the provisions look a lot like antitrust law. They bar anti-competitive conduct or empower the regulator to provide remedies for that conduct. Here is just an example of one of them. They all have slightly different wording. This is from the Shipping Act. The article focuses on conduct powers, and that's in contrast to a lot of the other writing about shared agency powers, which tends to be about merger review. And it really presents 3 case studies of agencies with those powers, perhaps better called mini histories for those who feel that case study has a particular meaning. So I began by researching industry regulators that had exclusive powers. And by that, I mean there's some sort of exemption from general antitrust law that coexists with an industry regulator that has sort of a substitute power to combat anti-competitive acts. And I started there because it seemed to present the greatest potential for harm if the regulator didn't use its powers. And so those are the first 2 case studies, the Federal Maritime Commission under the Shipping Act and the Surface Transportation Board for Rail, which has antitrust-like enforcement powers under something called the Staggers Act. This is the sort of deep research you get to do when you have a teaching leave, where you're like, what are these statutes that no one's ever heard of that now I'm up to my eyeballs in? And the third case study, I look at an agency that actually shares their antitrust-like enforcement powers with DOJ, and that's the U.S. Department of Agriculture, under a little statute called the Packers and Stockyards Act that enables both of those entities to prevent anti-competitive conduct in meat packing. And I chose the USDA because its antitrust provisions are so powerful on their face. So a mix of independent and executive branch agencies, exclusive and shared power. And the prior writing here, really notably by Peter Karstensen, Christopher Saggers, also Howard Shalansky, it looks at each of these industries one by one or statute by statute. And the contribution of this article is to really draw together that knowledge across industries to show that the problem that it identifies is recurring or even common, this problem of antitrust abandonment. And to examine it really as a problem about agencies, not just a problem of substantive law, but a problem of which agencies have the power to enforce it. And the good news is it's easy to summarize about 200 years worth of research here. In each of the case studies, the article finds a fairly striking lack of enforcement by the industry regulator. These agencies do not use their antitrust-like powers to any great extent and have not used them over a lengthy history. So just as an example, it talks pretty heavily about the Federal Maritime Commission. In the entire history, it's had these powers, Section 41307 of the Shipping Act. It's never once brought a single case against a common carrier. And by that, I mean shipping carriers who hold a lot of concentrated economic power in the industry under what are essentially legalized cartel agreements. The FMC initiated one case. It was against ports, not carriers, and it lost. So the STB and USDA don't fare all that much better, although it varies slightly by provision for them. But I think it's safe to say that these provisions really exist on paper. And the draft also argues that this inaction isn't justified over time. It exists alongside increasing concentration and often complaints of misconduct in a lot of these industries during particular periods of time. And so the paper labels this antitrust abandonment, and that's used to describe sort of a disuse of statutory antitrust enforcement powers over the long term by these industry regulators where that disuse isn't justified or explained. And the paper argues that this pattern of abandonment can create real harm, primarily because it creates these unjustified and persistent gaps in competition enforcement in certain portions of these economically important and concentrated industries. And so it leaves a sort of void in competition oversight. No one is enforcing antitrust law or a substitute for it in particular areas of these industries. And on the harm story, I want to be clear, the antitrust exemptions here aren't wholesale. And so that's something that's developing still in the draft. It's not all of shipping or all of rail. It's certain cartelized agreements in shipping and certain tariff traffic in rail that the harm story applies to. And so I think in a large sense, the paper is part of a broader set of problems where shifting regulation over time fails to meet antitrust law. If we want to think of them as complements, then they should probably meet each other at some point. And so to that extent, it really echoes into Howard Shalansky's work, where he argues that economic cycles of deregulation can create gaps, but he looks primarily at judicial doctrine. Here, the gap is caused by something else, a combination of agency inaction and legislation. I am not keeping track of time, so feel free to interrupt me at any time.
When you're ready.
All right, so I will say the paper is really arguing that this sort of abandonment is particularly harmful where the industry regulator has exclusive authority because there's really no backstop of general antitrust law. And so making the point that competition oversight for it to be effective at the seam of antitrust and regulation depends not just on the substantive law, but on the institutional implementation of it. And so I'll say on the solution or implications section, this is the last part of the paper, and it talks about what antitrust abandonment means for the allocation of antitrust enforcement power among existing agencies and for the future. And it suggests in particular that lawmakers and perhaps also antitrust agencies should stop expecting these industry regulators to use their enforcement powers. That the problem is in the disuse itself, but also in the expectation around use. That we continue to treat this disuse as changeable, almost unexpected. History shows that it isn't. And so as a specific example, there's a recent Biden executive order on whole of government competition, and a piece of it I'm critical of, where it pushes the FMC, one of the entities in the paper, to use its enforcement powers more when such action's pretty unlikely, and if it occurred, might actually do more harm than good by virtue of inexpertise. And so then it talks a little bit about how we could fix that through legislative amendment, but also a shift in the perception of a need for antitrust enforcement where it meets regulation, to view them more as overlaps. And to that extent, perhaps sort of echoing some of what Hiba has to say in her paper. And I'll wrap up with just what the paper says about the future. A lot of these agencies were given their antitrust powers a long time ago. They're traditional industries. But the paper considers what the antitrust abandonment means for this debate over digital regulation that everyone in this room knows is happening right now. And it argues that it would be a mistake to exclude antitrust law or antitrust expert agencies from competition enforcement under a new digital regulatory scheme, which, if one were to go ahead, that antitrust should continue to apply in conjunction with such regulation as a failsafe against these sorts of abandonment. And how we might, if we do decide to give exclusive power, do so in a way that's more dynamic on the face of the legislation to guard against these sorts of incidents happening in the future. So I welcome all of your comments and questions and would greatly appreciate them, given that this is definitely still a draft.
Thank you, Erika. Harry, let's go to you.
Well, thank you, Daniel, for asking me to do this. Thank you, Erika, for writing the paper. Boy, there are a lot of people here, too, so we should thank everyone for, having a nice Friday where you can think about these great issues. I don't have slides. Those are still Erika's. I don't have slides. But what I do have is sort of demonstrative evidence. So I decided to take this off the wall of my office this morning, actually, while Eleanor was in doing a call. This is something I've had on my office wall for many years, actually. And it's what's called a routing slip or a buck slip. It's actually the first case that I handled when I was in the Antitrust Division at the Department of Justice. This shows you how old this piece of paper is. And it's a case called American International Drive-Away versus United States and ICC. I won't ask for hands as to how many people know what ICC is, the Interstate Commerce Commission, or, as the famous Ralph Nader study said, the Interstate Commerce Omission. I was assigned this when I started at the Antitrust Division. I was assigned this case, and I argued that the Justice Department should go into court to oppose what the ICC had done. Now, and then I have to read this to you. The buck slip says, this case is assigned to you for briefing and on condition that you get a haircut before going into court for argument. It was the 70s, okay. I didn't get the haircut. But the point is not that as I love this one, obviously. So the case was about an application by what was called a drive-away company. They would drive your car. Instead of you driving it, they would drive your car across country or other places. But you needed a certificate of public convenience and necessity at the time from the Interstate Commerce Commission, and the ICC had turned them down. We've got enough of these companies, they said. I took a look at it, novice lawyer. I said, what's enough? We need competition. Isn't that what we're about? Now, the United States was a statutory respondent in these cases, along with the regulator. And I said, we should go in and confess error on the Interstate Commerce Commission. This wasn't a novel thing by me. The Justice Department had been doing this for a while. And so I took the position that the Justice Department should say, the ICC was wrong. They should have granted the certificate. We need more competition in the public interest. So I go into court, and the district court judge, is a very good district court judge. First thing is my first case. He looks at the lawyer for the driveway company and says, I understand why you're here. And looks at the lawyer for the ICC and says, I understand why you're here. Then he looks at me and says, but I can't figure out why you're here. This is a great way to start my professional career. So I tried to explain to him the importance of competition. I bring this up for a couple of reasons. First of all, the conflict in one way or another between antitrust or competition principles and regulation is the conflict of antitrust. Goes back actually to 1897. It's always been important and significant, and I'm really glad to see Erika raise it in this paper because it is important that we talk about it, and it continues to be important. So that's the first thing. The second thing is to underscore something that's in the paper, and I think maybe needs a little more emphasis, which is the historic institutional role of the Justice Department in getting competition into sectoral regulation. And the department has played this often, and now both agencies have played this role. So two aspects for this. Now, at the same time, the age-old nature of this makes Erika's paper more difficult because there's so much literature out there. And the second part of it is what I call the Tip O'Neill phenomenon. All regulation is local. So not local geographically, but every statute, as you just said, it has its own peculiarities, its own technical detail. It's sort of a mess to bring together into one paper, and you've risen to that challenge, but it's still a challenge. Then there's the third part, which I call the Casablanca effect. And it goes like this. Earl Butz wants to protect the packers, under the Packers and Stockyards Act. He's the Secretary of Agriculture. I'm shocked. There's protectionism going on by the regulators. So somehow you have to get over the normal antitrust responses. I'm shocked. What do you expect? This is what regulators do. They protect the regulated firms. So how do we deal with that? So I think those are the challenges. Coming up with a new way of looking at it. I love Antitrust Abandonment. It's a great title because the Surface Transportation Board now deals with a lot of railroad abandonments. There's sort of a rough harmony between that. But it does draw attention to something that I'd like maybe a little more detail in the final paper, which is exactly what kinds of agreements might be covered by. These are not approving mergers. We all sort of know about that. But, sort of the perhaps more minor, but still competitively important things that the agencies might do. You do mention some of them. I just wasn't sure what all they were, and I think it would be improved if we got a little more sense of that detail. So that's one of the suggestions. I have more time than I thought. Good, I can just keep talking. The second thing is, what exactly is the harm from the abandonment? Would they do antitrust better if they actually carried out these mandates? And you could argue that maybe they would. I think you could flesh this out in certain ways. The Federal Communications Commission, in doing its merger assessments, and has ended up working more with justice. The banking regulators seem to take on more of the usual sort of apparatus for assessing mergers. The unfortunate part of doing that is that it gets you beyond the three agencies that you picked. So that just makes the paper more challenging. But maybe some sense of what the harm is. But the real thing that I was looking for, I have to say, when I started reading the paper, and I'm sorry that Tim Wu isn't here because we could just rag on Tim, is the effect of the executive order, President Biden's all-of-government executive order, which you mentioned, Erika, in 2021, because the paper takes the position, at least in some parts, that the effort is futile. Would be nice to tell Tim that right here when he was here, but we can't. So now we can really sort of up the screws. Tim, what did you think you were doing? This was never going to work. But I think there's an important contribution that's yet to be put in this paper that I think is not just history, not just Casablanca, but what have they done? What actually has gone on? And there is dispute in the antitrust community. I'll hear people say, what? This is like a complete failure. Nobody's doing anything. And then the enforcers will say, what? The EO is great. Look at all the things we're doing and the agencies are doing. Now, so someone's sort of right and someone's sort of wrong. But I think we haven't really seen a toting up of this. And there are things going on. Maybe they're going to be ineffective, or maybe there's not enough. But I think that would be a really useful part. And it was almost the first thing I was looking for. But here's what I'm going to tell you about. If there's abandonment, if this can't work, let's see if it's worked. So that would be the first thing. The second thing is the other side it's the institutional side that I really sort of started with, which is, what are the agencies doing, in fact? Have they, there are areas in which, for example, the FTC has been very involved, often with state regulatory action. But in these federal sectoral regulators, what's been going on? What have the agencies done? Have they stepped up? Have they been participating in rulemaking? Have they, and they haven't done nothing because, as you point out, there was big price fixing in ocean shipping. There were price fixing cases, maybe less successful with broiler chickens, but the two of the areas that you mentioned. So somehow to deal with there's not no attention being paid. Let's just see what the attention is, and can we be critical? One of the things that I think many people wonder about, and I do, as much as we're concerned about big tech and those efforts which are taking enormous resources from the agencies. Are they then dropping the ball a little in certain areas that they've historically played an important role? Regulation might be one of them, because there is this important historical role. So I would suggest two of those things. The third one, and you mentioned this, which is what do we learn for digital regulation? Now, I think if you want to write the next book, that's a great focus in and of itself. I worry whether you're going to be able to put. That's a very complicated question in itself. So it may be that you want to say, oh, by the way, if Congress, God forbid, ever does something in this area, hold our breath. What would we learn? That's a whole other problem. And I think it is a problem. And the DMA would then come in and all of this and how we think about it. So again, extremely important topic. Lots of very important information in the paper. But I think important things to develop out of it that will, up its relevance currently. So I do want to end with a final anecdote. I'm sorry that Tim is not here, because I was at a panel at a conference that Steptoe Point put on in December, and one of the real participants they had was one of the commissioners from FERC, Federal Energy Regulatory Commission. And so I asked him, so what have you done under the EO? And he sort of said, what EO? So I'll give you his name. Maybe you can, my guess is he'd be perfectly willing to tell you that. So again, thanks so much for the paper. Very much enjoyed it. And it's, I think, going to make a real contribution to the literature.
Thanks, Harry. Juan.
Well, I want to start off by also thanking you, Daniel, for inviting me to be on this panel, and also thank Erika for giving me the opportunity to review your paper and provide thoughts and feedback as you continue your drafting process. And given that the focus of this session is on operationalizing antitrust, my role on this panel is really to kind of come at things from a practical perspective and what are the kind of issues that would have to be addressed if you're going to try to implement some of the things that are proposed in the two papers. And so I've used my experience at DOJ and in private practice to kind of think about some of the things that are suggested in the paper. And Erika, you obviously, the main thrust of your paper is, DOJ and FTC are the antitrust experts. They should be the agencies responsible for enforcing antitrust laws and competition. And so we should eliminate exemptions as much as possible or narrow them and give more authority to the DOJ and FTC, which I think all of us who want to see vigorous enforcement wholeheartedly agree with that. But from a practical perspective, and we hear this from the current leadership that, they're just strained so thinly, right? So one immediate practical question is, do we have the bandwidth? Do we have the resources? Do we have the staff to take on more things as we're trying to do more with less? And so obviously any changes to the law or DOJ or FTC's mandates would have to coincide with additional funding, additional resources. So that's something that policymakers, legislatures would have to take into account if they're going to shift more responsibilities to DOJ and FTC. Another thing you talk about in your paper is, in an ideal world, we want DOJ and FTC enforcing the laws and being the competition enforcers. But if not, then maybe we could set up regimes where they're sharing that power with the primary regulators for an industry. And I see the pros and cons to that kind of approach, but some practical questions that kind of popped into my head under that regime would be, what would happen in instances where the agencies reach different conclusions in an investigation? Should the regulators defer to DOJ or FTC as the competition experts? Or conversely, should DOJ and FTC defer to the regulators who have the subject matter expertise and might be taking a holistic view as to what's better for the industry overall? So that's just one thing you might want to consider as you're trying to flesh out some of these potential regimes is, how do those disagreements get resolved? And, there's other industries like telecommunications and airline where DOJ shares power with other agencies. And so that might provide some helpful guidance as to how you might handle those kind of issues. The other thing that kind of popped into my head is, could companies exploit any differences between the agencies in enforcement actions, right? Like, well, our primary regulator said this is fine, this conduct is fine, this transaction is fine. Why is DOJ coming in here second guessing the subject matter experts? So that's just another practical consideration to think about as you continue fleshing out some of these potential regimes. You also propose towards the end of the paper the concept of power shifting. So if we're not going to give exclusive power to DOJ or FTC, and we're going to leave that with the regulators, maybe we have some kind of sunset type provisions that allow DOJ or the FTC to step in if there's a pattern of non-enforcement by the primary regulators for the industry. And I guess one question that popped into my head as I was kind of reading that part of the paper is, who gets to decide when there's been enough enforcement, and how do you make that determination, right? Are DOJ and the FTC going to have essentially like auditing powers to kind of go and tell the primary regulator, well, show us what you've been doing and why you've reached your decisions and how you've reached those decisions? And is that going to create friction between antitrust enforcers and primary regulators to the point where you might have less enforcement because they're not sort of viewing each other as partners, right? And so could you have unintended consequences under that kind of system? And then does that kind of system create incentives for agencies to bring cases that probably shouldn't be brought, right? Just for the sake of being able to say, we're not asleep at the switch, so leave us alone. Don't try to intrude on our jurisdiction, on our power. And then I guess the other thing that popped into my head is, does this create the risk of politics influencing law enforcement decisions if you have maybe Congress kind of coming in and saying, well, we want to see what you've been doing so we can decide whether this power should shift to the FTC or DOJ. So those were some sort of just practical questions that popped into my head as I was reading through the paper.
Thank you, Juan. So Erika, I'll just share 3 quick reactions I had, other than huge enthusiasm for this frontier of thinking about competition. So the first was, I wonder if you're missing an opportunity to make a big splashy theory claim. So the standard reason why we don't have antitrust in many regulated monopoly settings is because we don't think we can get the kind of competition that antitrust exists to protect. So we tend to think, gosh, maybe because natural monopoly dynamics or whatever else, we will do better overall with universal service requirements, price and term regulation, whatever it might be, as a substitute for competition. And we'll either do almost as well, or at least as well as we can, as a substitute. And I sense that idea comes up a couple times, but I think it gets kind of short shrift in your paper. At a couple points, you suggest that this concern that we can't really have competition in a traditional way is overblown. You say, look, there's been some partial competition in shipping, and it's been fine. But I sense there's a much more ambitious theory critique here, which is that the standard case for utility regulation as an alternative to traditional competition and antitrust either isn't made out, so that these are not alternatives, utility regulation or competition, or even to the extent that they are, you can to some extent have both regulated monopoly and antitrust. And I think that's a really ambitious, exciting idea, and I would love to see that getting the spotlight rather than living in the margins. Maybe there's a project like Against Public Utility Law that's living in the shadows of what you've written. Second, you're telling us a story that we're invited to see as a bad one, about a bunch of things going on that if only the antitrust cops were in town, would be stopped. But you're pretty light on telling us what specific practices are going on that antitrust can and would be able to stop, that would be harm to competition in a regular antitrust sense. And you talk about concentration, but that alone isn't the kind of harm that we can expect antitrust to fix. Talk about opaque contracting practices, plenty of those in the rest of the economy, not the kind of thing that antitrust is necessarily well suited to solve. So what is this category of behaviors that if only the antitrust cops were in town, they would be able to stop? Third, and just kind of echoing something that Juan said, I came away hungry to hear a bit more about what can and should be done. So you're saying, look, like it's not the answer to ask these poor overstretched agencies, whether it's Maritime Commission or anything else, to add even more to their overburdened plates. So we should move this task back to DOJ and the FTC. Notoriously overstuffed plates and capacity-constrained institutions. And that got me wondering, where's private enforcement in all this? So the vision of antitrust that I take from the paper is one where the federal government's the only actor. But gosh, if ever there's a role for private enforcement to give injured market participants or even nationwide classes of consumers the ability and incentive to detect and push back on harmful practices, why not a private right of action? So could we hear a little bit more about enforcement outside the federal agencies? So those are three very quick reactions from me to a project that I love and I'm really looking forward to watching evolve.
Daniel, couple quick things. So one quick reaction to what you said regarding private enforcement. I mean, historically, a lot of the private enforcement has sort of followed on to government enforcement, right? So if there's no government enforcement, then private enforcement might not necessarily sort of be help fill the gap. But hopefully, it could be an option, right? But just something to think about, Erika, as you're continuing. And the other thing that I meant to mention in my first suggestion was one thing that I thought about is, are there alternatives to the proposals you put in terms of like power shifting and power sharing? One thing I thought about, could the agencies come up with a system, right? Essentially giving the primary regulator a right of first refusal. So DOJ or FTC could say, this transaction's been announced. We think it's anti-competitive. Are you guys planning to do something here? If not, we're moving forward, right? That might be a simpler system than kind of this power shifting system that could create some friction, right? So and that could be sort of like some kind of agency memorandum of understanding type of thing. I don't know, but I just thought like some kind of right of first refusal type of practice might be helpful here in this situation. So I wanted to mention that as something for you to at least think about as you're continuing your work.
So that's a bunch of reactions from us. Let me open it up for maybe one question, 1.5 questions. Pallavi.
I was curious if you looked into the UK's concurrency regime, so that they have the Competition and Markets Authority as is the overall antitrust enforcer, but then you have the
Financial Conduct Authority and a bunch of others that, they've longstanding, it's almost kind of the reverse of the US system where those other regulators are supposed to also be able to enforce the Competition Act from 1998. And then I think in 2013, they passed some new legislation to kind of clarify how that would work. And one of the things they put into there is that competition is supposed to be the paramount value, and which I think is kind of helps to push that point forward. The CMA just last fall put out a request for information about how this has all been working for the past 10 years, and they're supposed to put out a report this spring. So that just might be something useful to think about and look at as a comparative example.
All right, in just 1 minute, do you want to respond to some subset of what you've heard?
Absolutely, and it's hard to pick, but my number one question that I put a star beside was, what did Harry's hair look like at the time that he got that notice? Doesn't everyone want
Is there a
to
picture?
know? Yes, so follow
Should've
up
had a
there,
slide.
really essential. No, but joking aside, I take your point very much so, Harry, that the Biden executive order could change all of this. And that's why I start the paper with a period in 1957 where a Senate committee was going to change all of this by pressing the USDA to use its powers. And so I think it's sort of history repeating. It's not the first time we have refocused on trying to get these agencies to act. I also think it's too soon to really tell if they have, although I will say the DOJ has now brought a couple of Packers and Stockyard Act claims kind of tacked on to a larger antitrust case in chickens. So time will tell. The danger of predicting things is it's about the future. But I think these are all really well taken and rich points of feedback. I think one of the most interesting things is sort of the agencies themselves on the inside. And if you get a chance to look at the paper, I've been thinking of doing a follow-up that has some interviews with these agencies, sort of a what EO. And one of the most magical quotes is someone who reviews cartel agreements that are illegal by the FMC, and I'll keep this short. And the analyst said on the agency's oversight of these contracts, I joined in 1961. All we looked for was grammar and punctuation. If we got something sophisticated like a pooling agreement, we'd come in and say, what do you want this agreement for to the shipping carriers? And the carriers would say, none of your expletive business. So I think there's probably a rich history you could get from the agencies themselves. Also, I'll just wrap up by saying I think the solution is the part where a lot of the feedback was, and I think that the solution doesn't necessarily fall out of the problem. I think the descriptive part of the problem is the primary contribution, and I think it's great to debate sort of ways that we could fix that. And beleaguered agencies, I think the question goes back to what Harry was saying, which is, how are the agencies spending their time? You know, are the big tech cases the right place to spend it? Or are these industries like shipping and rail, which affect every other industry, also a good way to allocate those scarce resources? Or is that really just a cliched resource question that these agencies need more of?
All right, let's thank Erika. All right, so now from abandonment to labor antitrust, Hiba, take it away.
Okay, so I will start out with a disclosure. I served, sorry about that. I served this past year, ending in October, as an expert advisor at the FTC, focusing on labor competition issues. So I will say that none of my remarks today reflect the views of the FTC or any of its commissioners. Okay, so just for those of you who are not necessarily all that familiar with labor antitrust, it's been a big year and will be and continue to be a big year/years for labor antitrust. Some of the basic big news items have been, escalated enforcement under Section 1 against criminal no poach, a bunch of civil cases against no poaching agreements and other forms of horizontal collusion between employers and the wage fixing, and also information sharing contexts. Section 2 case against the UFC is going to trial in April. It's the first labor monopsony Section 2 case. And of course, for those merger hawks, the merger guidelines, revised HSR forms will be, enforced, will be challenged in court, and will be litigated, and there's a lot of room for potential new doctrine there. And then the FTC's broader enforcement in the context of obviously the non-compete rule, and enforcement in the non-compete context more broadly through the Bureau of Competition, but also Bureau of Consumer Protection enforcement in the context of labor as well, gig labor, independent contractor status and coordination, and so on. So it's a big time for labor antitrust, but as I was working in the agency, it was clear to me that there's lots of unanswered policy questions. And they're not just kind of really, really big idea policy questions, which are, of course, first order and important to kind of iron out. But they also are about like basic nuts and bolts, methodological questions, benchmarking, right? Like a range of implementation questions that I think are really important, not just for the agency to develop and think through, the FTC and DOJ, state AGs, but also for the antitrust community to think through, and then and to start talking about and think through a broad range of proposals. So up until now, the standard literature has really focused on, okay, well, how do we adapt traditional industrial organizations' models to labor markets and assume that labor markets mirror product markets. And as you can see from the merger guidelines, it's clear that the agencies think that labor markets are somewhat different, right? There are all sorts of matching costs. There's complications with respect to market frictions that exist in labor markets that are unique. But that's a clear admission by the agencies that labor markets are sort of unique. But then there's other types of questions that come up in the ordinary course that I think are really flummox a lot of people, right? So just some examples. Measuring anti-competitive effects and damages, right? So say you're trying to figure out what the effects of conduct or a merger might be on delivery drivers. Let's just imagine a hypothetical where it's, a merger between some company like UPS and FedEx, right? How do you benchmark a competitive wage? Is the competitive wage a non-union external labor market wage, or is it a union premium wage? What are the adequate substitutes? When firms compete up wages in a labor market, even if they were to bid up to a union premium, let's say, without there being a union, right? Maybe the best case scenario for some workers. Would they be offering, quote unquote, acceptable terms and conditions of work, end quote, right? And this is, and I use that quote deliberately because it's a language from the antitrust statute, the Norris LaGuardia Act. Even if all workers wanted was more voice over shop floor conditions or a flexible schedule, right? Would a quote unquote supra competitive or union premium wage be the right measure for whether or not there's an anti-competitive effect? How do you do a quality adjusted wage analysis? And in the context of clear evidence that that workers prefer certain types of, for example, are willing to pay for certain types of dignitary interests over and above wage increases or things like that. How do you deal with that type of evidence? Also, unfair labor practices. So when under the National Labor Relations Act, employers can violate unions' rights, workers' rights to organize, collectively bargain, and strike. That the agencies have asked for evidence, disclosure of evidence of that in the HSR forms. If employers commit unfair labor practices that violate the National Labor Relations Act. Is that evidence of market power, monopsony power, or is that unlawful conduct, right? Because it reduces workers' countervailing leverage. How does that count as an unfair method of competition? Or what about lawful union busting with some level of monopsony power that reduces workers' bargaining leverage? How do the antitrust agencies deal with that? And where do you draw the line in terms of employers suppressing workers' countervailing leverage and ability to exercise their voice at work? There's how do you deal with remedies? So if there's an anti-competitive merger that where it's clear that the agencies find some effect on labor market competition, and they're drafting a request for a remedy in a court, or they're thinking through remedies in a consent decree. How do they deal with requests by workers that all they want as a remedy is a union? And how is there a structural remedy in that context? Okay, so these are all unanswered questions. And as I was trying to think through, how do I anchor my answers to these questions as I'm thinking through them just more generally as an antitrust scholar, as a labor antitrust scholar, I wanted to know fundamentally, do the antitrust laws have a labor and wage policy? Is there something in the statute that I can kind of anchor any analysis to? And yes, they do. They actually very clearly do, in ways that honestly never really come up in the context of a lot of the labor antitrust literature and debates about labor market regulation. So what I wanted to do was to write a paper that would really explore what the antitrust laws themselves had to say about labor regulation and labor policy, something that the new labor antitrust has pretty much entirely ignored. And I ended up up doing a lot of digging into progressive era economic intellectual history and the social scientific debates that informed the policies that Congress ended up enacting in the Clayton and Norris LaGuardia Acts. So the first part of the paper covers that history. And it really covers, honestly, what was clear to me was a battle between neoclassical marginalist economists and institutional economists and social scientists who were responsible for thinking through and drafting the language of the two antitrust statutes that I focus on in the paper. And the institutional economists won. Right? They won against marginalist economists. And so I'll briefly kind of go into that if I have time, but happy to talk through that more historical aspects of the paper in the Q&A. So the second part then explains how current enforcement contravenes the plain language of those statutes, their purpose, and the legislative and intellectual history that inform them. But it also, I argue, contravenes public policy. What social science tells us now are the labor market realities that enable employer buyer power with significant social welfare harms. Essentially, that part argues that applying neoclassical industrial organizations methods that became the exclusive modus operandi for tackling anti-competitive conduct in product markets to a labor market or labor markets more generally has usurped congressional policy on the face of the antitrust laws that declared that labor was not a commodity and ought not be regulated as an article of commerce through competitive, market-based wage setting. And then in the third part, I try to offer alternative approaches beyond just IO for regulating the unlawful exercise of employer power under the antitrust laws and propose a default rebuttable presumption in favor of employer power and drawing from broader interdisciplinary social scientific approaches to ascertaining employer power and its harms in order to overcome any successful rebuttal. I don't know how much time I have left.
You're ready. You're fine.
I have a lot more, so
You want to take another minute?
another minute. Well, okay, so one thing I do want to keep, I think I'll take my minute to actually focus on the statute, and because I know there'll be commentators that focus on the other aspects of the paper, but this is just something that I think a lot of, or at least I as an antitrust practitioner myself, so my background is before I was a professor, I was a plaintiff side class action litigator at Cohen-Milstein, so I was working on primarily labor antitrust cases under Section 1 and Section 2. So when I was a baby attorney, I started out on that UFC case, but I also worked on nurse wages and some other Section 1 cases in labor. So during that time, and since then still, I never really looked at, I mean, everyone I think knows the first part of section of the Clayton Act, right? Of Section 6, that labor is not a commodity or article of commerce, but I never really kind of read closely the policy purposes of the Norris LaGuardia Act. And so I just actually, I think I'm going to take my minute to just read that part of it so that's fresh in people's minds and trying to kind of think through what this language means within the current kind of framework that we're so used to applying, coming from IO in analyzing kind of competition-based goals of antitrust in the context of labor markets. So what the Norris LaGuardia Act recognized, and this was based on not just, this isn't just a policy statement based on, kind of abstract democratic principles. It was in fact based on a significant regulatory infrastructure that was developed at the state and federal level, where economists and social scientists were administering rate regulation in the context of wages, were collecting the most vast amount of data that the government ever had on wage differentials, industry-wide, occupation-specific data, established departments of statistics in the relevant agencies, including, in the antitrust agencies, but beyond, and had more information than they ever than they ever had before about evidence of employer power, and we're discussing it as evidence of employer power. And so that was the kind of context. It wasn't just a commitment to, so for example, a free labor ideology of some kind. It was entirely evidence-based. And so that was a kind of background for informing a policy that was declared in the Norris LaGuardia Act that under prevailing economic conditions developed with the aid of governmental authority for owners of property to organize in the corporate and other forms of ownership association. The individual unorganized worker is commonly helpless to exercise actual liberty of contract and to protect his freedom of labor, and thereby to obtain acceptable terms and conditions of employment. Wherefore, it is necessary that he have full freedom of association, self-organization, and designation of representatives of his own choosing, to negotiate the terms and conditions of the employment, and that he shall be free from the interference, restraint, or coercion of employers of labor, in the designation of his representatives, or in self-organization, or in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. And then it went on to strip courts of jurisdiction to grant either legal or equitable relief to enforce undertakings or promises that conflict with this policy, including yellow dog contracts, but also arguably potential consent decrees that ignore this fundamental public policy of the antitrust laws. I have a lot more to say about the paper, but I'll leave it to commentators and happy to answer questions.
Thank you, Hiba. So I love this project, and I want to just start by identifying a couple of reasons why, other than the fact that it taught me a lot, and the fact that it's a fabulous complement to Erika's paper. All right, so Erika is in some sense arguing against antitrust exceptionalism, and Hiba's contribution is to say, no, antitrust exceptionalism is exactly what we need, and the problem with the current movement to revive labor antitrust is that it's not exceptional enough in a bunch of ways. But that's not the only reason I love it. Number one, I love it because antitrust discourse is full of kind of very thin, armchairy, self-serving history on all sides of the debate. This isn't new, right? It goes back to pick your favorite ideological opponent who misrepresented the history of antitrust. And what Hiba gives us is a really deep, careful, textured, historical account of a long and messy conversation and all the plurality of values associated with it. So just the opportunity to bathe in that knowledge was a delight. Second, in ways that sort of transcend just labor antitrust, I read this project as helping to unsettle the consensus that antitrust has a unitary, easily understood, clearly defined normative goal or criterion. I think it's always been the case that antitrust normative orientations are tangled. You know, welfare matters in some ways, not clear whose or under what circumstances. The nature of conduct matters in some ways. Market power matters in some ways, but the things that we value create market power. And I think a lot of the time we cloak those disagreements in antitrust discourse under the idea that there's a normative competition that we all agree we're protecting. And I see you as helping to really unearth the more complicated normative terrain beneath. And the third reason I love it is it pushes back on something that drives me a little crazy, which is the idea that traditional labor antitrust as an enforcement project is just a means of picking up a bunch of $20 bills left on the sidewalk. It's all really easy. The only reason that this hasn't been done robustly for decades and decades is either cowardice or capture. I think it's much messier than that, including for reasons you illustrate. But in standing in for Tim, I want to show my love through critical questions and reactions, and I have a couple of those. So thing number one is that you're pretty long on rich, helpful description, but you are pretty short on prescriptive suggestions. And I read a tension in the paper between what you are telling us we should do. So at some points, I hear you saying, oh, what we need is effectively traditional antitrust, but against a unionized baseline. So union premium wage rather than atomistic wage should be our benchmark for what constitutes a competitive or infra-competitive wage. But I don't think that's the limits of your ambition, right? I think what you're trying to tell us to do is not just move the competitive baseline in a very traditional sense, but to really rethink the normative orientation of the project itself. So big ticket point number one, I would love for you to flush out and flesh out and spotlight the normative orientation of your reconceived labor antitrust. Point two, on that note, I want to ask what that norm is and why it is a plausible fit with the antitrust laws we've had. Because Section 6 of the Clayton Act, Norris-LaGuardia Act, none of those created additional antitrust causes of action, right? So the tools of enforcement and litigation are still Sections 1 and 2 of the Sherman Act, Section 7 of the Clayton Act, Section 5 of the FTC Act. So if we want to see sort of a reconceived visions of the weapon of antitrust in this context, there's got to be a plausible doctrinal reason why the practices you describe are restraints of trade, unfair methods of competition, monopolization. And the kind of practices you're talking about don't seem to me always to fall into that category, right? Deterring unionization, exploiting labor side market power, practices that reflect such power but don't necessarily exclude rivals. And in fact, you say in the paper, I'm just going to quote, non-competition-based harms were the type of harms, in this context, that Congress sought to vindicate through antitrust regulation. So this is not an Erika-style story about another agency or another normative project being given different tools. This is a reconception of the tools we've got, and that's a fabulously interesting claim, right? It's one thing to say Section 6 of the Clayton Act removes labor from antitrust. It's another thing, and I think it's what you're getting at, to say that Section 6 transmutes antitrust for labor. And if that's the claim, that should be front and center. It's so exciting. It's counterintuitive, but that's what makes it fun. And in fact, I even sense you more than once as wanting to let go of competition as an orienting concept. I have a lot of sympathy for that. I don't think we should use competition as a tool that does work, but it's a really controversial idea. Would love to hear more about what that project is. Finally, just to wrap up, one thing you don't really talk about is what the borders of this special zone are, right? So a huge battleground for labor antitrust today is who gets the benefit of the exemption and why? And this is a terribly tangled battleground. It's not clear whether labor law gets to make that decision for antitrust. Employees versus independent contractors, blockbuster case now out of the First Circuit dealing with jockeys, really kind of placed this squarely on the doctrinal agenda. You seem to be suggesting a new view of antitrust for all workers, including high-margin professionals who are a long way from your traditionally unionized examples. What are the limits of the rethinking that you're describing? So those are just three reactions from me. And now let's hear from Juan.
Sure. And again, coming at it from sort of a more practical perspective, some things that popped into my head as I was reading your paper and your proposals. And I'm going to start off by focusing on your suggestion that we have a rebuttable presumption that employers have market power. So the first question I had was, okay, could the agencies point to some statutory text or case law to go into court and say that presumption is valid, Your Honor, and you should enforce it? Mm-hmm. And so could defendants, for example, use the Supreme Court's decision holding that market power can't be presumed in patent tie-in cases to say, no, Your Honor, the Supreme Court has spoken to the contrary, and so, what the agencies are advocating for here, should be rejected, right? So as an enforcer, like, what are you going to sort of hang your hat on when you go in and advocate for having that presumption? Another question, as an enforcer and as a court, right, should this presumption apply in all cases, right? So, for example, should the labor market have certain characteristics before the presumption is triggered, which would be similar to sort of the presumption for anti-competitive mergers, right? You have to have a certain level of concentration before the deal is presumed illegally. And so I'm not sure whether, you're advocating for that, or you're just saying, that presumption should apply automatically in every single case, right? So another question I had was, should the presumption apply in cases involving small businesses, right? A lot of the focus is on big businesses, but what about if you have a small employer? Should that small employer be saddled with a presumption that it has market power? Or what about if you have evidence that employees have comparable alternatives, right? So should the presumption apply there? And I know some of these arguments, you could probably say, well, the defendants could raise that in rebutting the presumption, but I think as enforcers and courts, you're going to just naturally ask, is it appropriate to apply the presumption from the beginning? Another sort of question I had, should the presumption apply in markets where you have labor shortages and then workers arguably have more leverage there, right? So for example, in the healthcare industry, there's been labor shortages after the pandemic. And so some people would argue that workers have more leverage there, or where you're dealing with C-suite executives or highly specialized employees. I think some people would argue that the bargaining leverage is very different there than the workers that you're focusing on in your paper. And so the question would be, should the presumption apply in those instances as well? And then I kind of alluded to this already, but a natural question is, if it's a rebuttable presumption, what kind of evidence would be adequate to rebut the presumption? So for example, should certain market share thresholds be applied? Would evidence that employees have options and have left for better opportunities be sufficient? Would evidence that the employers in question has been increasing wages, increasing benefits, improving working conditions be sufficient? Would evidence that the conduct in question wasn't done with an improper motive and had some pro-competitive benefits, whether it's innovation, better products, lower prices, taking on a dominant player, would that kind of evidence be sufficient to rebut the presumption? And then as an enforcer, right, you'd have to ask yourself, as you're conducting your investigation, and if the company you're investigating comes in with all these types of evidence, and you conclude there's a good chance that they're going to be able to rebut this presumption in court and have a pretty persuasive story, do you still bring the case anyway, right? Just to show vigorous enforcement and hopefully have a deterrent effect. But at the same time, risk bad precedent that you have to then deal with in future enforcement actions. And, from talking to folks, that's been one criticism of the DOJ no-poach cases, right? Some folks felt like they brought cases that arguably had weak facts, and they should have, the initial cases should have been sort of airtight cases that, they had a strong chance of winning, right? And then you get those early victories, you get that good precedent, and then you send a message to employers. So again, those are the kind of things that enforcers are going to have to be kind of thinking about. And so kind of turning to the union premium wage proposal, and you say, we should have that as the benchmark rather than sort of a market wage benchmark. And again, I think enforcers and courts are going to ask, all right, why is that the appropriate benchmark, right? And so, for example, if you're dealing with a case where the industry or category of employees don't have a history of organized labor, how do you come up with that benchmark? And why should that benchmark be applied in those instances? Would that benchmark be appropriate in cases where the workers in question voted against organizing and there's no evidence suggesting that that the employer tried to thwart that exercise of their vote, right? So that would be another sort of scenario where courts and agency would have to decide, should we be applying that benchmark? And another thing, I know one common tactic that merging companies often use to try to get their deals through is, they secure labor support for their mergers. And you see this a lot in the airline industry, for example. And typically the agencies ignore that because it doesn't really kind of reflect sort of the potential competitive effect of the transaction on consumers and things like that. But if you're adopting a sort of union premium wage, are you having the unintended consequence of kind of helping defendants employ those types of tactics, right? So something to think about. And I think I'll stop there for now because I've probably been speaking for too long, but just wanted to flag some of those sort of things from a practical perspective.
That was fabulous. We've got time for a couple of questions. So let me invite your questions. Sir, at the back.
I want to address my question to Harry. When you talk of Tim Wu not having a chance in Washington, is that partially because Chuck Schumer's daughters, one works for Google and one works for Facebook, and that the amount of money that the platforms throw at their lobbyists amounts to probably $1 billion and change, where they can buy every vote available. So did Tim, was he up against the wall?
So I don't want to be seen as saying that Tim didn't have a chance in Washington. He did have his chance. He is the eminence grise behind the executive order, which is why I mentioned him for some in the room who may not know. So, and I think has been very important. I was going to say effective, but effectiveness is a funny word. I think that the policies that he espoused and that are in the executive order, the agencies have made good headway on, actually. And I'm not talking about necessarily the regulatory part. I'm a little skeptical on that, but in general. So I see Tim's returning to academia as a promotion. So I'm glad to have him back. But there's going to be another administration at some point, depending on under whom, I don't know. None of us do. And that's coming. So I think all of our discussions, in a sense, have to really think about that. This is an important aspect of how antitrust develops. As for Senator Schumer, I never believe that our senator from New York is on the take. And I mean that seriously, without regard to who his daughter's working for. To me, more important are the votes of the California Democratic delegation. So, but that's my armchair politics, not based on anything I know. But I do want to come back to Tim, who I think made a great contribution while he was in Washington with the Biden administration.
I want to give the last word to Hiba, perhaps take a minute or two, and if there's anything you want to share by way of reaction to what you've heard or some of the engagements, the floor is yours.
Yeah, no, I mean, sorry. These comments were so incredibly helpful. So thank you. I very much take them to heart. I think one of the things I'd leave with is in thinking through, antitrust always deals in some ways with counterfactuals, right? It's dealing with the but-for world. What would competition have looked like? What types of, and this is something that Erika's work also touches on, what types of privacy protections could any kind of consumer protection or antitrust statute afford when there aren't clearly stated preferences for those, right? These are all, I think, questions at the edges of antitrust enforcement. But I feel in some ways lucky that one important but-for world that Congress envisioned for labor market regulation is stated clearly in the statute. And I think that there's some aspects of this which is like, well, the but-for world that Congress imagined in the context of labor market regulation is a world where workers feel free to make decisions about their pay and about their conditions of work, free from employer coercion and collectively. Not just in terms of individual wage bargains. And that kind of like collective thinking and collective coordination that's deliberately envisioned by the antitrust statutes is part of the justification for a union premium, for example, being the but-for benchmark that we should use rather than the benchmark of what a marginal worker would be offered and negotiated for in terms of his or her working terms and conditions of work in an employment contract. And so it's a challenging thing to try to theorize, but also to operationalize. But I'm inviting myself, but also everyone here to go down that path.
Let's thank Hiba. And thank this terrific panel. All right, we're now going to break for lunch. We'll be back with a special panel of a slightly different kind to talk about framing research in some of the fields we've been talking about. So enjoy lunch, and we'll see you for that. Thanks again.